Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Al-Hazmi bin Ahmad Salim. Alternative Dispute Resolution (ADR) refer to a variety of dispute settlement method and technique that parties can utilize with the assistance of third party to resolve disagreement. ADR processes are usually less expensive and more faster. ADR procedures are generally collaborative and allow the parties to comprehend each other's perspective. Mediation, arbitration or neutral evaluation are examples of ADR procedure for resolving conflict without resorting to litigation. Mediation is a voluntary procedure in which a mediator promotes communication and negotiation between parties in order to help them reach a mutually beneficial agreement. The Mediation Act of 2012 aimed to make this procedure easier. Arbitration is a private process in which disagreement is resolved by a neutral third party. The difference between mediation and arbitration is that in mediation, the party have complete control over the process and outcome, but in the arbitration, it decides the outcome of the proceeding and the parties are bound by that judgment. Neutral evaluation is incorporate element of both decision making and non-decision making. The neutral evaluation main goal is to make litigation less expensive for parties by lowering pre-trial costs and improving pre-trial practice.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Zakwan bin Muhammad Al-Azali, and my part is about the benefits of alternative dispute resolution. There are a few benefits we can get from alternative dispute resolution. The first one is it costs significantly less than going to court. Court matters, even those that last only a few days, are extremely expensive. Resolving any conflict in this manner can result in significant financial loss, especially if the issue is complex. The next one is greater flexibility and control in resolving disputes. Parties can establish their own terms and conditions for how the ADR process will be conducted. Stipulation regarding discovery, hearings, meeting, limitation, and other case matters are some examples. Hearing and deadlines can also be scheduled by disputing parties based on their schedule and availability. Parties can choose an arbitrator who is an expert on the subject matter of dispute rather than being assigned a judge, which is beneficial in cases requiring expertise and specific knowledge. Not only that, ADR also can give better and faster resolution. In general, court hearing take a long time to schedule, resulting in long waits for any issues to be resolved. In contrast, informal mediation can occur much faster, increasing the likelihood of a quick resolution. Disputes can be resolved through ADR in less time than litigious matters on average. I think that's all from me. Thank you.
Hai, Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Muhammad Hafizul Farhan bin Muhammad Shah, and today I will be presenting to you the use of alternative dispute resolution ADR in employment conflict. There are 2 points of the use. The first one is technique of dispute resolution. In order for ADR to be used, practitioner must be prepared to demonstrate how ADR can help to resolve conflicts that are influenced by economic, demographic, and technological change. Experts should be prepared to create or initiate ADR application to modify existing technique and adapt to it. The changing format of conflict. All ideas of industrial action and court hearing may be avoided. For the second one is the mechanism of ADR in Malaysia. Malaysian employment dispute resolution is distinguished by the division and specialization of many agencies and institutions. All connected departments must explicitly identify the procedure and process in order to avoid overlapping area of responsibility. Conciliation is the most commonly employed method of ADR in the Industrial Relation Department. In the labor department, the method to conflict settlement of ADR system is different. So that's all from me. Thank you.
Hi, my name is Abdul Qadir Jalani bin Mazir, and I would like to present about alternative dispute resolution policy. First of all, my first point is litigation. ADR is an option for resolving a case in litigation, or if the Department of Justice makes that decision. Secondly, declaration of right. This policy statement does not establish a basis for a judicial review or whether or not the policy is being followed. Thirdly, confidently, the parties can freely express themselves without fear of their secrets being leaked to other parties or the public. Last but not least, a relationship to others. It doesn't replace collective bargaining agreement, other legal or regulatory or contractual ways to settle dispute, or there are ways to handle the disciplines.
Hi, my name is Akmal Sofi, so I'm going to present about the advantages and disadvantages of the company that use ADR. So first of all, the advantages are selection. The company might be able to select the arbitrator or the mediator. This might allow to select someone with expertise in the field, which can be very, very advantageous. Secondly, reducing the risk. Participating in alternative conflict resolution, so the company might be able to reduce the potential for negative outcomes. Last but not least is lowering the cost. Alternative conflict resolution can avoid to pay for expert witnesses and the process quicker than litigation. So move on to the next, which is the disadvantages. First of all, lack of appellate options. If the company doesn't agree with the decision, they can always file an appeal. Secondly, limitation on remedies for the company. The agreement only can be reached through arbitration or mediation. And lastly, disadvantages on the payment. The neutral arbitrator or mediator will probably charge a high fee for the service. So that's all from me. Thank you.
Next, the legal challenge under the Code of Civil Procedure. The Code of Civil Procedure 1908 states that mediation is mandatory and that the court shall itself mediate or refer the dispute to the legal aid officer or the pleader of the parties or the mediators from the panel to mediate when all the contesting parties attend before the court. But there is no provision to compel the parties by if any of the party does not attend before the court to mediate. And lastly, most lawyers oppose ADR because they fear that if the dispute is resolved, it will have a negative impact on their income. Many lawyers mislead or discourage their clients from using ADR, but there is no provision to hold the lawyer accountable if the ADR process fails. That's all from me. Continue to the next part.
So as for conclusion, in a nutshell, alternative dispute resolution ADR is increasingly being used in conjunction with judicial system to help resolve disputes. Besides, arbitration is the main ADR method used to settle large commercial disputes. Alternative dispute resolution ADR methods includes mediation, facilitation, conciliation, fact-finding, mini trials, and many more. Finally, in Malaysian, employment dispute resolution is distinguished by the division and specialization of many agencies and institutions. So that's all from us. Thank you.